Okay, hi everyone. Thank you for coming. This is how the PRO Act will harm workers, entrepreneurs, and job creators. This is brought to you by the Institute for the American Worker in partnership with Americans for Prosperity and the State Policy Network. I'm Vinnie Vernuccio, and I'm president of I4AW, and I once again want to thank Americans for Prosperity and the State Policy Network for partnering with us on this event. Also for Katie Vernuccio for running logistics. This, once again, is the harms of the PRO Act. I know you've probably all heard of the PRO Act. Essentially, it's the smorgasbord of bad ideas. You've probably heard how it tilts the playing field against job creators and the devastating effects it'll have on business. But today we're going to have a different focus. Today we're focused on the harms that it causes workers, entrepreneurs, and on small business. From eliminating right to work, to jeopardizing employee privacy, to making independent workers employees instead of entrepreneurs, to damaging small business owners by harming and attacking the franchise model. We have an all-star lineup today, but before I introduce them, I want to let everyone know that we will have ample time for question and answer. If you look to the bottom of your screen, you'll see the Q&A button. If you do have any questions during the event, please put it in the Q&A and we'll hopefully be able to get to it at the end. We're leaving a lot of time and hoping to have a good back and forth. So please do not be shy about putting in questions. So now I'd like to introduce our all-star panelists. First, we have Karen Anderson, who's the administrator of the Freelancers Against AB5 group. She founded it in November 2019, shortly after the disastrous California AB5 law was signed by Governor Newsom. She has a Facebook group that currently boasts 19,000 members, comprised of independent contractors, small businesses, and anyone who is affected by AB5, and she'll be able to give you a little bit more details on that during her presentation. After Karen, we have Terry Bowman, who has been a lifelong Michigan resident, has worked as an hourly worker at Ford for the last 24 years, both in production and as a tool and die journeyman. Terry has spent 11 years as a labor reform activist, testifying in state legislatures around the country, and even before Congress. Following Terry, Damon Dunn is founder and managing member of Laginta Industries, an international franchise association board member. He is also a Dunkin' brand franchise owner. Damon grew up in rural Texas and was raised by his grandparents. He hunted and fished to stretch the government welfare and food stamps that sustained them. He earned a full ride scholarship to Stanford, and Damon went on to play both college football and had a career in the NFL. He's a fellow in business and economics at the Pacific Research Institute and writes the monthly Free Market 101 column for PRI's Right by the Bay blog. Batting cleanup for us is Akash Choudhury, who is vice president of economic opportunity initiatives at the Stand Together Chamber of Commerce. Akash, before going to Stand Together, served as a professional staff member at the Committee on Education and Labor in the U.S. House of Representatives. And prior to that, Akash was director of policy at Americans for Prosperity, and he was previously selected as Forbes magazine's 30 Under 30 for law and policy. So with that, Karen, can you tell us what happened to freelancers and independent contractors in California after AB5 and how it is similar to the PRO Act?
Well, AB5 has been a perpetual dumpster fire in California since before the law went into effect on January 1st, 2020, and it's still a dumpster fire. And the stories started pouring into my group before it went into effect. They started pouring in right around December from musicians, interpreters, journalists, and a whole host of professionals from across the vast swath of professions. And I'm here to tell you some of these stories. We've identified in my group over 400 categories of professions that have been affected. And let me just give you a brief list off the top. Auctioneers, cancer registrars, animal shelter consultants, audiovisual techs, after-school programs, casting assistants, children's theaters, professional Santa Clauses. Shout out to my friend, Mrs. Claus. She was affected. We have a Grammy Award, two-time Grammy Award winner, whose band was decimated by AB5 when it first went into effect. We have court reporters, interpreters, translators, transcriptionists, florists, funeral officiants, event planners, guitar makers, lactation consultants, genealogists, dental techs, physical therapists, pharmacists. We have a pharmacist, licensed pharmacist with doctorate degrees who lost her career overnight because of AB5 and still hasn't gotten it back. Massage therapists, notary publics, real estate appraisers. They've just recently received an exemption, but they were dead in the water because of AB5, and they're supposed to be independent by their very nature, yet they were caught up by this law. Nurse practitioners, paralegals, process servers, radio engineers, sign language interpreters. The effects on the deaf of heart and hearing because of a lack of services due to AB5 has been really detrimental to that community. Sheep shearers, tutors, videographers, opera companies, the list goes on and on. We have entire industries and sectors decimated by AB5. One of them is the independent filmmaking industry, and that would include documentarians and producers and video editors and that kind of thing. That particular sector is really under the radar right now, but they're very much impacted. We're starting to hear a lot about community theaters in the press now. They're starting to cover it, but we knew about it back in January because theaters were closing right, left, and center because of AB5. Opera companies, children's playhouses, because the cost of putting on a production, converting everybody to payroll would have increased that production by $30,000, $40,000. So these small theaters just had to close their doors, and this was before COVID. Independent health professionals. That's a whole thing I'll address in a moment. We have veterans of the meetings and convention industry we're hearing from corporations saying we don't want to deal with bringing our events to California. It's too much of a landmine. The wedding industry was really hammered. Now, disproportionately, the women and marginalized citizens are very disproportionately affected by AB5. Seniors, in particular, who have been thriving until now with their self-employment opportunities, just completely dead in the water. We have a lot of seniors in our groups who are transcriptionists, people that are in their 60s and 70s who lost their livelihoods. They were making great money, and they can't be expected to find something equivalent in the same field in a full-time job because of their age. Family caregivers, that's why I got involved in this fight. People who have to stay at home and work from home so that they can at the same time care for their loved ones. So we have tons of stories of people who had to pack their sick loved ones, cancer, people who, the husband with stage 4 cancer, and pack them in a U-Haul and flee the state because it was life-threatening to them, this law. The disabled and the chronically ill who need to work at home, they can't go into the traditional workplace because of their situation, lost their careers and livelihoods overnight and were dead in the water. And the stories in my group were heartbreaking with that particular segment. These are people that stay at home and work online as virtual assistants, transcriptionists, translators, journalists, dental billers, tutors, bookkeepers, that kind of thing. Lost their careers. Now we have a lot of these exemptions that have come through. The law picks winners and losers. People with the best lobbyists, people with the loudest voices got exemptions, but you have hundreds and hundreds of categories of professions that are still left out in the cold. Even though the journalists got an exemption and that onerous cap, the infamous 35 cap on our submissions was lifted, the journalists' lawsuit continues because there's still unconstitutional restrictions on their work. Employment law attorneys, we're here in our group, are telling us that law firms across the Golden State are advising their business clients to stay away from independent contractors in California, even if there is an exemption, because they're radioactive. We have people like graphic designers in our group who were exempt from the top from AB5, and they lost their clients anyways because they don't want to deal with it. So there's 107 total exemptions. Uh, the law itself, the ABC test, which we're talking about today, the same test that's in the PRO Act, is 130 words. But with AB5, the exemptions total 4,000 words. You just read it's just a convoluted mishmash of all sorts of hoops and fine print and caveats. A lot of these people who have exemptions can't take advantage of their exemptions anyways, because there's all these multi-factor tests. Even if you try to shoehorn yourself into the exemption, you can't do it. The audits, this is the dirty little secret of AB5. The freelancer isn't really the ultimate target of AB5. Businesses large and small are the ultimate target, and the freelancer is the roadkill on the way to going after these businesses, because the fines for misclassification in California are massive. You have up to $25,000 per violation, plus back pay, back benefits, back taxes, workers' comp fines of $10,000, overtimes, meals, breaks, all of it retroactive by 3 years, not to mention the attorney fees it costs to defend yourself in front of the labor board. So it can be lethal. So we have also in our group examples of people under audit right now. And these are not big companies, Uber and Lyft. These are small, one person, mom and pop, woman owned businesses. They call me, they tell me their stories. There's one gal who has a quadriplegic adult son who was under audit for videographers, contracting with a videographers. And she was under audit, and she told me that when she asked the auditor, what if I can't pay these fines? It'll bankrupt me. The auditor looked her in the face and told her that the state would put a lien on her house and render her and her quadriplegic son homeless. We have another
Karen,
one.
that is absolutely heartbreaking. Thank you. And I mean, the main thing I want to point out is that even with those exemptions that you're talking about, that same ABC test in AB5 is in the PRO Act, but the Congress didn't even learn the lessons from California. There are no exemptions in the PRO Act. There's similar fines to AB5, and it is just absolutely heartbreaking. Karen, I was wondering in the chat if you wouldn't mind sharing some of those lists. We're about to go to Terry, you're on deck, but we've been getting a lot of question and answer of where can they find all these stories? Where can they get this list? So I know you sent it to me. If you wouldn't mind putting it in the chat, and we're also going to follow up with a bunch of links and a bunch of resources after the briefing. So Karen, thank you so much.
Well, can I just say one thing? You can go on to Freelancers Against AB5 on Facebook and just come and join, and you'll see links to those lists, but I will put them in the chat.
Great. Thank you, Karen. Terry, do you want to tell us about what the PRO Act would do to right to work and how it would take away your freedoms?
Absolutely. Well, thank you, Vinny. And hello, everyone. What an honor and privilege it is to be with you today. What I'd like to do is start back and go back over a decade, back in the late 2009, early 2010, and give you an idea of why I'm actually here today. After reading my union newsletter and reading an article that basically said that Jesus would be a socialist and that he would approve of Obamacare, I had had enough of union propaganda. And I stood up and I said, you know what? It's time for me to become a loud advocate for what we call in Michigan worker freedom, which is, of course, right to work. In fact, I spent every minute of my free time over the next couple of years working hard to make Michigan the 24th right to work state. And believe me, when you're a loud, outspoken advocate of right to work and working in a union shop, there were a lot of consequences that came along with that. And you know, the ridicule, the harassment, the name calling was unbelievable. In fact, I had a board on my wall that I called my wall of shame, where every name that I had been called because of it, I wrote down until I ran out of white space on the board. And the threats that I was receiving from every angle made me actually alarm every window, every door in my house, just to give yourself a sense of security, because these threats were so bad. But even in the midst of all that, we worked hard. We got a lot of people together. And in December 2012, we passed a right to work law in Michigan. And ever since then, I've been traveling the country talking on behalf of the forgotten American worker on why we need workplace freedom and other labor reform. And perhaps I've been in your states as well. In September 2015, my union contract finally expired, and I was able to proudly resign my union membership. But of course, I still have to accept union representation as a condition of employment. And today I work side by side with the same workers I've worked with for 24 years in harmony and peacefully. So I'm proud to say that that's true. And unfortunately, now, all these years later, I find myself having to defend workers again from union officials and executives who cannot honestly seem to be able to offer a service fairly to workers. Instead, they insist on forcing workers to financially support them, whether they do a good job or a bad job. Now, the proponents of the PRO Act say that it's necessary to protect their right to organize, PRO. But we all know that that's not true because they've always had the ability to organize, even in right to work states. As an example, the UAW, my union, has spent decades trying to organize right to work states down in the southern states. They're not winning. They keep losing because they don't seem to have a product that workers are willing to invest in. But they've been active running organizing campaigns in southern right to work states for decades. So if the PRO Act isn't really there to protect the right to organize, what is it really there for? Well, we'll have to see that. The truth about the PRO Act is that it is profoundly anti-worker. This act will steal away my rights, my freedoms, my protections, and transfer and outsource those rights, freedoms, and protections to a unwanted union official and union executive. By eliminating states' rights and getting rid of right to work laws, this act will take away an American worker's only refuge and our only ability to hold our union officials answerable and accountable. And that's through a right to work law. And I think you would agree and know as well as I do that, us workers, we need those rights, freedoms, and protections, don't we? Union officials tend to sometimes engage in, well, let's say in my case, out and out corruption. It's something that I know all too well of. Perhaps all of you have heard about or have read the intense and the widespread corruption that's going on in the UAW and the federal trials that's going on with it. Two of my UAW presidents, countless union officials and executives have all reached plea deals or have been found guilty and are actually in prison. The proponents of this PRO Act want to force workers in the private sector like me to continue to financially pay tribute to these unions, even in the midst of a federal corruption trial. I believe, and I hope you do too, that this is not only immoral at the least, but it is a violation of my civil rights and a violation of my property rights. Why would any elected official, and I ask this question all the time, and I hope you do as well, why would any elected official, and it doesn't matter what party they belong to, vote on a bill that will take away my rights, my freedoms and protections and give them over and give union officials and executives absolute power over me? It seems that the full burden will go on our shoulders, our workers' shoulders, or should I say maybe our pocketbooks. Finally, think about this. If the PRO Act becomes law, these elected officials, they will not have to financially support organizations that they may have a problem with or may not agree with, but I will. And many workers like me will have to support unions that they have a moral problem with. In fact, these elected officials will be slapping each other in the back, high-fiving union officials, and congratulating themselves ad nauseum. As workers, then we have to take up the burden. This bill will destroy every success that we have had in the workplace and will force me as a worker once again to surrender my wages to an unwanted union. The Supreme Court in the Janus decision found in favor of public sector union workers. Do workers like me in the private sector deserve any less rights? Am I somehow less of a person because I work in the private sector? Well, I think the answer is no. So, on behalf of the forgotten American worker, we need your help today. The PRO Act overwhelmingly and overpoweringly wages war against workers and our families, and our rights, our freedoms, and our protections are on the chopping block. So thank you so much, and I look so much forward to the rest of the program.
Great. Thank you, Terry. And just to underscore, I believe there are 2.8 million private sector workers that will lose their right to choose whether or not to financially support the union at their workplace, meaning 2.8 million private sector workers in the 27 right to work states where unions could actually get them fired for non-payment if the PRO Act passes, not counting the scores more workers that either could be organized in right to work states or taking away the ability from the non-right to work states to pass such a law. So that's really powerful, Terry. Thank you for your story. And Damon, would you mind telling us what the PRO Act would do to the franchise industry, but more specifically to small business owners around the country?
Sure. When I first got to Stanford as a freshman, I remember meeting with some alumni. They were introducing new athletes to freshmen, alumni that had come back, and there was an opportunity for us to build networks. And I'll never forget a guy by the name of Duff Stundheim. He told me, he said, those who are afraid to take risk end up working for those who do take risk. And I'm making that comment because it's very important. Those who are afraid to take risk, those who are afraid to start their own business, to go out and take that risk, end up working for those who do take risk. And that was his way of encouraging me by going to Stanford. Think outside the box, have greater expectations, think about owning your own business. And I think that's a very important value. And I want that value to run through the comments that I make the rest of the day. When I look at the PRO Act, there are two particular provisions that I think create an issue. Now, I understand that there are people who have, magnanimous, goals they want to achieve for people through this PRO Act. I think that the unintended consequences is that it will accelerate the income gap between the low income and the higher income. And I say that for two particular reasons. If, for example, I work for Dunkin' Donuts, I'm a franchisee. Dunkin' right now, they do not take on the liability for any of the responsibilities that I have as a small business owner. But in the PRO Act, what we're finding is that the ABC test and the joint employer standard is actually going to make the franchisor responsible for the actions of the franchisee. And if Dunkin' is going to take 100% of the liability and the risk, then they're going to want 100% of the upside. If they're going to take the risk, they want the upside. And right now, the small business owner goes out, manages his own business. But if Dunkin' can be sued as a franchisor as a result of what these unaffiliated small business owners like myself, franchisees do, then they may as well take all the profits. Because right now they take 10% of your top line sales, and those are your royalties and your marketing incentives. But we're making somewhere between $200,000 to $250,000 in net operating income on each of these stores that we're building. So if they're going to take the risk of liability, then they may as well own those stores and pull in, not only that 10%, but pull in all the $200,000 to $250,000 of net operating income. And what that will do in turn is increase the income gap between low income and high income. I say that for two reasons. First, when you start a business and you're, a small business guy and you're not within the franchise model, you have to go to a bank and they're going to ask you to put up, 25, 30% down to be able to buy whatever infrastructure you have to buy. They're going to require you to look at a track record to prove what your net operating income has been, because they're going to give you a loan based upon how much income you have coming in, minus all your operating expenses, minus your new debt service, and then another 15 to 20% on top of that, just in case you hit a down cycle in the market, so you can continue to service their loan. They're also going to look at your business operations experience. And if you don't have experience, it makes it really difficult to get a loan. Now, when you're in the franchise model, those things are different. You can put as little down as 5%. Because Dunkin' has infrastructure for franchisees and has created bank relationships so you can have cheap access to capital. Secondly, Dunkin' comes in and they look at Dunkin's track record based on that location with that amount of traffic. What kind of sales historically has Dunkin' been able to drive in markets that are similar to this? And so they're looking at that track record of net operating income and not your own. And then lastly, Dunkin' comes in as a franchisor and they offer you, weekly, monthly, quarterly, and annual meetings for operational training, operational interventions. They're helping you run, operate, and manage this business so that's the support that you don't have as just a small business owner. If you kill the franchise model by making the franchisor responsible for all of the franchisee liability, then they're going to take all of the upside. And what you're going to see then, Dunkin' is going to become Starbucks, where they own all the stores and they make the $250,000 on each one of them stores themselves. And then guess what happens? That guy like myself that's making $250,000 on one store and the opportunity to own 2, 3, 4, 5 stores. Now I go from $250,000 to making $50,000 as an employee for Starbucks, basically, or now an employee for Dunkin' who owns all the stores. And this will disproportionately hurt the people who are from low income and people who don't have the networks to capital like I have. I went to Stanford. I have equity partners. I have those networks. But if you're a low income person and you don't have people, from Stanford or alumni or access to capital, you're not going to be able to benefit from the relationship of a franchisor where you can put less capital down, where you get operational training, and then you also get to depend on their track record. And so people who are wealthy, who own their own businesses, this won't impact because they'll always have access to capital. They'll always have a track record. They'll have people that can co-sign for them. But the people who are from low income, from the communities I came from, they won't be able to go into business. They'll be employees and they'll make $50,000 versus $250,000.
Wow, Damon, that's really powerful. I mean, I just want to echo that one more time. What the PRO Act would do is it would take business owners that can make up to $250,000 a year by taking a risk and turn them into employees making $50,000 as a general manager. That is horrible. Thank you. Thank you for sure. And I'm sure there's going to be a lot of questions for you. Once again, before we go to Akash, the question and answer box, it's right on the bottom of your screen. We are going to have time for question and answers at the end of this. I've seen a couple have been rolling in. Please use it, and we'll get to question and answer in a moment. But with that, Akash, could you tell us what you think the chances in Congress are of the PRO Act passing, and fill in any of the blanks that we may have missed during this conversation?
Sure, Vinny. Appreciate the opportunity to join. And I'm so appreciative of all three of the remarks we've heard so far. Right? We've seen and heard the horrors of the ABC test in California. A lot of the rhetoric around supporters of this bill has to do with workers' rights. As Terry walked through, it's workers' rights that are being taken away in this bill in order to empower union organizers and union bosses, right, with more power, more wealth, more control. And then to Damon's comments, he basically alluded to it, right? Entrepreneurship, it's a significant challenge, and what franchising does is provide a slightly more accessible opportunity to entrepreneurship for people who are sort of teetering on the edge of being, willing to take that chance that Damon talked about. I mean, I personally know people that have taken that chance. It's a huge challenge, and he mentioned that the franchisor then would assume all of the upside. The other thing they would assume is the control, right? If they now face all of these risks under the joint employer test of labor law violations and fines and all this stuff, I mean, there's tens of thousands of people like Damon out there. Why trust any of them with risk that ultimately is going to be borne by corporate Dunkin' in Canton, Massachusetts? They're going to take all that control away from Damon and turn him from an entrepreneur into just a middle manager, functionally eliminating franchising as we know it. So, folks on this call are probably familiar with most of the other sort of really bad lowlights of this bill, invading workers' privacy, taking, employers being forced to turn over their private personal contact information to union organizers, or home address, cell phone number, email addresses, et cetera, employer penalties and what have you. I think when you look at what's happening in Congress, it's really, really important to know why this is coming to the floor. So you mentioned I served on the Ed and Labor Committee last Congress. I was the lead staffer for the committee minority working against this bill. The subjects of this bill were given not one, not two, but 3 different congressional hearings with witnesses and testimony and question and answer session. Why was that? That was in order to create transparency, answer questions. And then the committee held a markup, right, where any member on the committee was able to offer an amendment. The committee minority offered 35, I believe, maybe 31 different amendments, where we were able to dissect different portions of the bill, hold standalone votes on things like the joint employer issue, like right to work, like the ABC test, like 24 other issues in this bill. What the Democrat majority did this Congress, they have skipped the entire committee process. No hearings, no markup. Now, why would they have done that? We have now exposed the amount of damage this bill does to small businesses, to employers, small business owners, workers, consumers, you name it. They have now been able to shield their committee members from any kind of transparency and accountability that comes with hearings. Just to give you one quick example, Vinny, one of the hearings on the PRO Act last Congress, the majority invited Richard Trumka, who's the president of the AFL-CIO, the largest federation of labor unions in this country. This issue of providing workers' private personal information to the unions was brought up, and he very clearly stated, he said that they need that information to go after workers, quote, at their homes and, quote, at the grocery store to go and get them to sign union cards. We would never have known that that was their intention, so clearly stated, had there not been a hearing that allowed him to say so. I mentioned those votes. We were able to see where lawmakers stood on a number of specific issues. They have now bypassed all of that clarity, all of that debate. This bill will now go to the House floor. There will be, presumably 1 hour of debate on each side. The only amendment votes, for the most part, that will be allowed are the ones that Nancy Pelosi's leadership team allows there to be on the House floor. So what do we see? We'll see a bill pass, pretty much along partisan lines, with a handful of Democrats maybe voting against, a handful of Republicans, unfortunately, voting for, but it'll pass on pretty narrow margins again. The difference now is we know that the Democrats have a very slim majority in the U.S. Senate. If they maintain the Senate filibuster that requires 60 votes for legislation like this to pass, it's obviously very unlikely that the PRO Act in its current form passes the U.S. Senate. But there's a number of possibilities here that are really worth considering for people on this call. It's not a foregone conclusion that this bill dies in the Senate. One, even if it doesn't get a floor vote in the Senate, if this gets so far as to get a hearing in the Senate Help Committee, or even get a Senate committee markup where they're holding amendment votes, that's a significant amount of progress given how rarely legislation like this is able to move in the Senate. We want to stop this from even being considered in the Senate committee. The next thing they might do, they might make changes to this bill. Just this morning, Congresswoman Susan Wild, she's a Democrat on the Education and Labor Committee, she told a reporter that they're willing to consider, Democrats are willing to consider and may even suggest some ideas that she thinks can make this bill a little bit more palatable to some Republicans to help them get to 60 votes in the U.S. Senate. Now, we have no idea what kind of changes those might be, but there's nothing they can do to this bill that should make it even remotely acceptable. No amount of tweaks around the edges should make this bill even remotely acceptable, but they might try to do that to get to 60 votes in the Senate. And then the third thing, of course, the nuclear option, if they decide, which I think remains on the table, if they decide to eliminate that Senate filibuster, then of course it's a live fire operation. They could get to those 51 votes that they need with Vice President Harris as the tiebreaker to get this to President Biden's desk. And then at that point, this bill, which I think it's very, very fair to say is one of the most economically damaging bills ever considered by Congress, could be signed into law by President Biden. So at this point, we're now in the week of the House vote, making those stories heard, making the real impact heard on small businesses, franchisers, independent contractors, union and non-union employees alike is absolutely essential, not only to members of Congress, but just out in the public sphere, right? Social media, journalists, friends and family. It's worth making that case now when this bill is front and center in the House, and then over the next several weeks as the pressure will mount on the Senate to consider this. So I think, it's really important that folks know kind of where this stands today, what the prospects look like going forward, and that they remain engaged beyond just the House vote that we'll see here in the next couple of days.
Wow, great. Thanks, Akash. We've got a bunch of questions, actually several very similar ones, showing that we have one from someone who says that she's a lifelong Democrat in California, but she sees the ABC test is destroying her career. Her question, I think, echoes a couple other questions that just came in, Akash, actually, while you were speaking. Would switching the IRS standard for independent contractors help keep independent contractors afloat? And would that make the PRO Act any less bad, to paraphrase?
Yeah, I mean, the ABC test is about as bad as it can possibly get when it comes to determining the definition of employee. So essentially anything other than the ABC test would be a step in the right direction. But I do think it's important to note that the ABC test alone, for one thing, it's highly, highly unlikely that they eliminate that portion. Karen mentioned that, it may or may not be the case that independent contractors are the primary sort of target of this bill. I think that's actually up for debate. That's the area where unions see the most potential to organize new employees, right? Turning independent contractors into employees and then go and try to unionize them, because they've obviously been unsuccessful with kind of traditional organizing drives at manufacturing plants, auto plants, what have you. So for that reason, I think it's highly unlikely they get rid of the ABC test. And even if they do, no, that doesn't make this bill even remotely palatable, right? You've still got the concerns around employee privacy. You've got the concerns around right to work, the concerns around joint employment. I mean, there are 24 other things in this bill that would continue to be damaging, even if you're an independent contractor, that, your rights and your economic opportunity would still be curtailed by this bill. And then really quickly, I saw another question there as far as the filibuster. That's a really wonky sort of term about Senate dynamics. Folks might have seen they just passed the stimulus bill over the weekend, and that needed just a simple majority, right? Because that was a bill that only had to do with tax and spending policy. They're allowed to do that because it doesn't make sort of, these sort of functional legislative changes, right? It only has to do with tax and spending. Those kind of bills can get through with a simple majority. Bills like the PRO Act require 60 votes to pass through the US Senate because of a mechanism that's called the filibuster. To get past the filibuster, they need 60 votes. They're having a lot of pressure. Senate Democrats are facing a lot of pressure from the far left flank, the AOCs, even, I imagine a lot of folks in organized labor are pressuring them to eliminate that requirement, right? Eliminate the requirement that the PRO Act needs 60 votes, which would allow it to pass with just the 51 votes. Vice President Harris is a tiebreaker. If they decide to make that change, eliminating the filibuster, then the PRO Act could pass with the simple majority, the 51 vote Senate majority that they have, and then go to President Biden's desk. You're on mute.
Akash, a couple more questions I think keep coming in for you. You are flooring everybody here. And they're all pretty similar as far as process of what happens if the PRO Act passes. We have one question saying, have any attorney generals expressed any intention to challenge the PRO Act? Another question on, could it get through during reconciliation? Another question, and Terry, I think you touched on this briefly, could this end up in the Supreme Court? So, Akash, could you just tell us, what you think as far as process goes? Is there other ways that they could pass the PRO Act, and is there other ways to challenge it if it actually passes?
Yeah, absolutely. So short answer, it cannot pass through reconciliation. Given that conversation they had on the minimum wage increase, I don't think there's a prayer that something this expansive would get through reconciliation. The other thing they could do, and we probably should have mentioned this on the front end, they could start taking pieces of this bill, right? I think what they like about this is, as Vinny mentioned, this is everything, right? This is the laundry list of labor reforms. But if they see their only opportunity to move the ball to, tilting the playing field in favor of organized labor, which is to be a piecemeal approach, then they might do that, right? They might take just that joint employer piece. They might take just the ban on right to work. They might take any number of things in the PRO Act and see if they can pass on a piecemeal basis. And who knows how the politics change in the Senate, both over the course of this session of Congress, future sessions of Congress. As far as if the PRO Act passes, I absolutely expect there to be legal challenges. I don't know personally if any one particular attorney general has spoken up, but just by way of reference, the PRO Act overturns 3 different standing Supreme Court precedents. Just to give you a sense of how radical this is, it overturns more than 70 years of established labor law and 3 different Supreme Court precedents. Terry touched on a number of the violations of employee rights, privacy, First Amendment, what have you. So I would fully expect there to be legal challenges. But again, who knows how those turn out? And so we'd obviously rather not take the chance of it even getting that far.
Okay, great. Thanks, Akash. And Terry, I think this one's for you. It deals with right to work and Beck rights. It asks if the PRO Act would eliminate our Beck rights, which I don't think they'd be able to do. It's not one of the ones that Akash has mentioned is going to be overturned. I don't think they could overturn that at the Supreme Court. But could you get into a little more detail of what Beck rights are, how that affects workers in non-right to work states, and essentially what workers would expect if the PRO Act passes and they do repeal right to work?
So the Beck rights are there for everybody in the United States, whether you're in a right to work state or a non-right to work state. And what it basically says is that workers do not have to pay that portion of union dues that specifically go to union political activity. The problem with the Beck rights, of course, is that who determines what is and what is not political activity? And that is the unions themselves. And one of the things that I did testify on is the fact that unions will engage in political activity, but they call it something different. They will call it education. They will call it organizing. They will call it different categories, but it is clearly political activity that they're engaging in. So the Beck rights themselves are not good enough to protect a worker from their money being used for political activity. So the PRO Act does not get rid of Beck rights, but the Beck rights do fall far short of protecting a worker from having their money used on a political or social agenda that they disagree with.
Great. Thanks, Terry. I think we have time for only one or two more questions. Karen, I think you might be the best to answer this. What would happen to business relationships like consulting under the PRO Act? I know you have a lot of freelancers and a lot of consultants in your group. What's happened to them because of the ABC test under AB5 that's pretty similar to what we're seeing in the PRO Act?
Well, in the business-to-business exemption in AB5, there's, I think, 11 factors that you have to meet. And one of them is that you can be a sole proprietor, LLC, or S Corp. But the problem with that is that having an LLC is not going to exempt solely, it's not going to exempt you from the law, nor is it going to protect the contracting relationship from misclassification violations. So that's number one. Number two, there's some onerous little caveats within that business-to-business exemption, and one of them really affects subcontracting. And so there's a lot of hoops and things that you have to jump through. The original B2B before they amended it was really unworkable for most businesses. So it's
I believe it. Yeah, it's one factor, but there's many other factors. And even if you have an LLC or an S Corp, if you fail the other factors, you're still an employee, correct?
That's correct.
That is really harmful for entrepreneurs. And early on, while you were giving that great list, we did have a question of where can we get a copy of these professions affected? I just want to point people back up to the chat box. Karen was good enough to add all her links, and we'll also feature those on our website, i4aw.org, i4aw.org, where we have a PRO Act explainer, both a longer and shorter version, both of which are coming out today that we partnered with the State Policy Network in, and also one of our hallmark backgrounders dealing with all the provisions of the PRO Act. Once again, if you're interested in more information there, it's i4aw.org. Americans for Prosperity, AFP.org, also has great resources on their website, as does the State Policy Network at spn.org/PROACT, and we'll be sending all of these links around. So with that, unfortunately, we are out of time right now. Our panelists, thank you again for really showing how the PRO Act isn't just harming business. It isn't just harming big job creators. It's harming individuals, individual workers, individual entrepreneurs, and individual small business owners. Thank you again to Americans for Prosperity and the State Policy Network for partnering with us on this briefing, and thank you to Katie Vernuccio for running logistics. And thank you all for taking the time to join us. This session has been recorded. We will be sending an archive along with several of the links that we spoke about here. And I hope you all have a good rest of the afternoon. Thank you very much.